Hello, everyone, and welcome to the Australian Law Student Podcast. I'm your host, Oliver Hammond, and on today's episode, I'm joined with my co-host, Francis, and a very special guest with me, the Honourable former Justice of the High Court, Michael Kirby. Thank you so much for joining with me today.
Thank you for having me.
I'll start off with my first question. Your tenure on the High Court was marked by many significant contributions to Australian jurisprudence. Could you share what it's like to serve as a High Court Justice, and how do you navigate the dynamics of working alongside other justices, particularly when managing different personalities and viewpoints and decisions?
Don't forget that by the time I reached the High Court of Australia, I had 12 years in the Court of Appeal of New South Wales, and before that 10 years as chair of the Australian Law Reform Commission, so that by the time I was appointed to the High Court, I was a pretty experienced professional. And the main point of professionalism is to manage your rage and to manage your disagreement and your puzzlement at the fact that your colleagues don't necessarily always agree with you. So that was not really a big problem. And the other justices of the court were all very experienced and able and self-controlled professionals. But what is it like to be a justice of the High Court? Well, it's not all that different to the Court of Appeal of New South Wales, which was and is a very great court. The Court of Appeal was more personally agreeable because the justices of the Court of Appeal were more inclined to agree with me, and therefore life, in a way, was easier. But the range of work that you got on the Court of Appeal was broader because you were dealing with every aspect of state law and of federal law, where the state court was exercising federal jurisdiction, and you had to keep at it. In my last year as a judge of the Court of Appeal, I think I signed something like 280 opinions, whereas when I was in the High Court, the annual output was only something of the order of 80. So it's a much lower production rate. But of course everything in the High Court is difficult because it shouldn't be there if it's not a difficult or controversial or important case. So anyway, it's a wonderful thing to serve on a highest national court. One of the things I did in my latter years in the High Court was to go to Yale University Law School every September, and there were gathered judges from a number of final national courts, the House of Lords as it was then, the Canadian Supreme Court, the New Zealand Supreme Court, the South African Constitutional Court, the Supreme Court of Japan, and so on. And it was very interesting to see how many of the problems that you were getting in the High Court of Australia were similar to problems that were arising in very different societies at about the same time. So that was an exciting and privileged viewpoint for a lawyer to be serving as one of 7 justices of the final national court. And I wouldn't have missed it for worlds, but there was a dynamic in the relationship, and through accidental factors, I was, for most of the time I was serving on the court, in a minority in many of the important decisions which we had to reach. I never complained about that. I knew how that had arisen, and I just accepted it and got on with it and expressed my view, because one of the strengths of our system is that the judges are duty-bound to express their own opinion. You may agree with them or you may disagree with them. And that is just how we were all trained, and it's what we all did, and the fact that there were disagreements was not something I allowed to interfere with my daily work.
I suppose perhaps in developing that sort of skill and in being able to manage differing viewpoints and that sort of thing, that occurred earlier on in your career as just in the Court of Appeal in New South Wales. Perhaps reflecting on that, was there any time early on where you sort of were there new skills that you think you had to develop?
Oh yes, every stage in my career were new skills. Last night I went to a function at the University of Sydney to celebrate the 150th anniversary of the Union, the University of Sydney Union, and I had to speak to them, and I had to speak about those glorious times when I was the president of the union, and before that president of the SRC, and before that president of the Law Society, the Students' Law Society, that was a very good preparation. And in fact, I often tell law student audiences that you should become involved in civil society or in the activities of student years, because I found my grades always got better when I was busy working in areas where I was good, where I performed well, and where I learned the great skill of being a good chairman. I am a very good chairman of meetings.
Yes.
And I got that because I spent all of my university years chairing student meetings. And you've got to have a skill to encapsulate the point that has emerged in the discussion, to do so fairly so that you're not being dishonest in presenting what is emerging, to give everybody a chance, to have a bit of a sense of humour, but not too much. And that was something that I took from my life as a student representative onto the courts that I later served on, and into the Law Reform Commission, where I served before I was appointed to the Court of Appeal.
I just wanted to ask, I thought it was interesting what you said before about the transferable skills and obviously the need to entertain a sense of humour to some extent. Do you think that there was a transferable skill in that sense, that you entertained similar senses of humour on the Court of Appeal or the High Court?
I don't think anything was ever exactly the same. My time in student politics was a different sort of challenge. My time in the Law Reform Commission was a different sort of challenge. And then in the Court of Appeal, different again. And the Federal Court was in there for a short time. And after that, my time in United Nations commissions of inquiry and activities of that kind, different again. People say, oh, he's the great dissenter. But I wasn't the great dissenter in student politics. I was the great assembler. And I had a career in student politics which was astonishing. I got everything in student politics. And people said, oh, this man is definitely going on his way to become a Prime Minister. But I just had to settle for being a Justice of the High Court of Australia. In my growing up, when I discovered that I was gay, in those days you had to hide that, and you had to pretend that you were straight, and I was pretty good at that pretense. But it was because of that when other students were out at the parties and drinking and enjoying themselves, I was running meetings. And I just became very good at running meetings, still am. And that was a good experience for me, and it was, but as I look back on it, it was really a product of the denial of an important part of any human life, which is the life of interpersonal relationships and of fun, enjoyment and so on. I was very serious, very focused and very hard-working, and basically I'm still all of those things. Yes. It gets a bit late in your life to change that very much. But if you want to have an easy life, law is not a job for you. Law is a job for application, for dedication, for attention to detail, for service to others, to remember that this is not a fun thing for clients. It's a serious matter, and you have to give your all to deliver the best that you can do.
Absolutely. I think, as we were discussing earlier, you've obviously spent a long time on the High Court of Australia, and in that time, Australia, since then, has undergone some pretty radical change and still is continuing to do so. I just wanted to ask, throughout all your time on the court and in relation to that now, do you feel as though you've encountered any particular arguments or perspectives that have made you reconsider or change your mind on any topics of issue?
Well, you keep your mind open. I mean, my general inclination is one very sensitive to human rights, and Chief Justice Spiegelman once said that the books that have been written on my life are all very interesting, but he's waiting for the psychodrama. He wants to hear the psychological analysis of it, so I just would always keep an open mind, and I think that was a very important feature of an independent judge, the rule of law, not going into court determined to do your thing, but determined to be yourself, to approach the problem in a way which is comfortable to you and your understanding of the law, but not to ignore where the principles of law, if the law is valid, and to apply it. A good illustration of that was the case of Minister for Immigration against B, which was a migration refugee case, and it concerned two little boys from Afghanistan who were under orders of deportation because their parents had arrived without visas. And the question was whether the provision requiring compulsory detention of the boys was within the intention of the Migration Act in dealing with detention, or did that provision only apply to people who could be expected to get visas, namely adults? And the family court, which had jurisdiction in the particular case, and decided the matter at first instance and on appeal, at both levels found in favour of the boys and said the Act only applied to adults in that respect. But the problem was, it was pointed out by the Solicitor General during argument, that the Act contained provisions for the searching of children in detention. And if the Act didn't apply to children, why would it provide for the searching of children? And the Act also had provisions which were contrary to the Convention on the Rights of the Child, which says that detention or imprisonment should be, in the case of a child, a last resort. And in Australia, it is a first resort. And so a question arose as to whether it was not consistent with the convention in a way that was relevant to the case. But we then looked at the record of the case, and it was presented to us by the Solicitor General correctly, and it pointed out that the Attorney General's Department officers had drawn the notice of the government and of Parliament to the fact that if this law is enacted, it'll probably make Australia in breach of the Convention on the Rights of the Child. And so it can't have been said that Parliament made a mistake, that it overlooked this conflict between its international obligations and its political imperatives. So for those two reasons, when I walked in, I thought, well, I would not be too upset to make a decision affirming the family court. But when I heard the argument, I just couldn't do that, because the argument convinced me that the decision of the family court was wrong in the case. So I had to say that, and the High Court was unanimous in the matter, and the unanimous decision was very painful. The two little boys and their parents were sent back to Afghanistan and were last seen going through the Khyber Pass, and it's a sad thing, but I never lost any sleep about it. I went home, had my dinner, spoke with my partner, told him about the case, and then I forgot it and just got on with the next case. That's what you have to do in the law. It sounds hard, but unless you can protect your inner psyche, you're not going to be able to do your best.
Do you think that, I suppose on a bit more of a personal note, do you think that you disassociate yourself with cases after perhaps the day is done, or do you perhaps is the law for you something that you live out every day, every living second of your day?
No, the law is my profession, and I didn't have and still don't have problems sleeping. You've got to be able to do that. You've got to psych yourself so you can go to sleep. But that, of course, means disciplining your life, not having late parties and other interruptions to a calm life. And fortunately, my partner Jan, who's put up with me for 55 years, is very calm himself. And so, and we decided very early in our relationship that we would not watch television, we would just talk. And that's important, to have a partner that you can talk to, get things off your chest, and then forget it and get on with the next case, because tomorrow is another day, and tomorrow was always another case, and was often a very difficult case.
Did you find it hard, though? I mean, it's often said that lawyers are friends with lawyers, they marry or are in relationships with other people in the legal fraternity. You know, they're constantly, I suppose, surrounded by that dynamic. Do you think it can sometimes be hard, I suppose, or can you still be friends and just not talk about things like that?
Well, I think if all your friends are lawyers, you're having a very narrow life. You should be mixing with people with different interests and different backgrounds. For various reasons, I came to have a lot to do with medical practitioners and people in the medical area, and so I didn't spend my whole life with lawyers. And also, I did a very strange thing. Before I was appointed to the bench, my partner Jan said, "Why don't we drive overland?" And I said, "Oh, I don't think I can do that. I'm a busy barrister. I'm making a lot of money. I'll lose all my clients." And that's what others said to me, including Michael McHugh, who was a colleague at the bar. He said, "It's the end of civilization. You'll never get the cases back," and so on. But I was convinced that this was a good idea, and so that's what we did. And we drove across India and into Pakistan, into Afghanistan, up into Iran during the time of the Shah, and then into Europe, and it was a wonderful experience. And we did it twice. And if I hadn't been appointed at the age of 35, that's probably what we would have kept on doing, because we loved it.
I think one thing I find pretty interesting, and something that I think a lot of law students don't take time to think about often, is the need for a judicial psyche, what you were saying earlier about not losing sleep over really tough cases like that. We often think about a judicial mind, but it's rare that we think about the spirit or the psyche of a judge. Is that something that took a long time to get used to? Did it come naturally to you?
I think it came naturally. I wasn't conscious of training myself. I didn't do yoga. I didn't have psychotherapy or anything of that kind. And I'm not criticising people who do that. I've known judges who have yoga lessons and who have training, but I was lucky that my partner was, I suppose, a kind of therapist, and I think that's so. Whether you're straight or gay, your partner has to share your life and share the stresses, and that helps you get through them. And I didn't have too much trouble with that actually, and I still don't. You've got to learn to get on with the next day, and that means you've got to have a good sleep. And I was always a very early worker. I still am. I would get up. Some of the silks I worked with when I was at the bar, the New South Wales bar tradition is start early. The Melbourne bar is start late and work late. But the New South Wales bar, I was often in my chambers by about 5 a.m. and I would then go and work with Busy Silk, who was there. And at that time, you didn't have emails and other forms of digital technology, but you did have the risk of the telephone, and the telephone would start taking you over by about 9 o'clock or 10, 9:30. And so this was a clear time and a good time for preparing. And I was always very conscientious. I wouldn't want you to think that I took law as a lightweight topic or profession. I always treated it very conscientiously, and I always gave my all, and I still do. And I think that's in one sense, objectively, a downside of choosing law as your vocation, because you then don't have enough time just to enjoy yourself. When I enjoy myself, I start to feel guilty after about half an hour. So that was just my experience. But I was very lucky in my partner, who's from the Netherlands, and the people of the Netherlands are very direct and very honest, very clean, very hard-working, and he has been a wonderful force for equanimity in my life and in the life of my family. All the members of my family, they've all become a bit Dutch. You know, we're very direct people and we're very honest people. And it actually was my partner Johan who said, after I was appointed to the High Court, it's time that we stop this pretense. You have to stand up. And I said, oh, don't you think we should postpone this until I leave the bench? And Johan said, no, we've got to stand up. We've got to stand up for the young people who are coming along. They should not have to suffer the duplicity and the obligation to pretend that we had to suffer. And of course this was coinciding with the HIV pandemic, and ultimately I agreed with what he said, and I think that was a good thing. I think that was a good thing for me, good thing for Johan, good thing for the judges, the courts, and a good thing for society. But there are still horrible people out there who have an irrational and unscientific attitude towards sexual variation, and that is just something that we've got to work at and improve. Also, women have to overcome prejudice against them. But it's amazing the change in the status of women in the legal profession that's come about in my lifetime.
Fair enough. I think one thing, this sort of flows on from what we were saying earlier about the early days in your career and developing a legal mind. Obviously the legal psyche came to you quite easily, but one thing I've always thought was interesting was the experience of a newly appointed member of the bench or the Court of Appeal or wherever it may be, rising up through the ranks of the legal system. How often in the early stages of your career did you feel overwhelmed, and are there any early decisions that you made that you think you might decide differently today?
I've told you that I was always a hard worker, and my solution when I was a young solicitor and when I was a young barrister was to get in early, to work very hard on my cases, to have as much as possible in my head, not to be in a position which was a horror thought for me, where a judge could work out that I hadn't read up a particular issue. I wanted to be on top of everything, and that was just, I suppose, a psychological flaw on my part. I always wanted to do well in exams or in anything else. When I was at primary school, at the North Strathfield Public School, I was asked by departmental officials to fill in a form which said what I wanted to be when I grew up. And I wrote, I want to be a judge or a bishop. And this was, I must have been aged about 8. So I was obviously a bit psychologically disturbed. But that was just my personality, and it's a good personality to be obsessive for the law. But you've got to be obsessive, be hard-working, do your work and give your guts to the case, but then be able to relax your mind. Otherwise, you'll go mad. There is a problem of alcoholism in the law. There is a problem of people having use of drugs and alcohol just because their personality can't cope with this sort of pressure or with the disappointments of life. I had some disappointments, but mostly my life has been really blessed by many opportunities and jobs and challenges, and so I'm not complaining about my life. But you've got to be able to roll with the punches, but not be a punchy type. You've got to be able to absorb it and then get on with the day's work. It's a professional job.
I wanted to ask you, I suppose, about your view on the Constitution. You famously held throughout your career that the Constitution's authority is grounded in the acceptance by the people. I wanted to know if your view has ever changed or is ever likely to change in response with the people, or perhaps you view it as perhaps a missed opportunity. Recent examples such as the voice referendum or are examples like that are part of representative democracy, or do you think that the judiciary should play a more active role in trying to help and shift society in a way which is perhaps deemed correct? Or
well, what is incorrect? What is incorrect? If the people decide, you have to accept that that is what the people decide. And if you're a Democrat, you have to say, well, that is the nature of the society I'm in, and if I don't like it, I should think of migrating somewhere else or spending my whole life doing some other activity. But I certainly did have a different view about the Constitution and the Grundnorm of the Constitution, the fundamental grounding of the Constitution, when I was at law school, because there we were taught the Grundnorm of the Australian Constitution was that it was an enactment of the Imperial Parliament in Westminster, and the Imperial Parliament had enacted it. They had the superior role and superior power to do so, and that was why it had to be interpreted in a way that was basically comfortable to the British legal tradition. And although some things were kept out of the Privy Council by the provisions of Section 74 of the Australian Constitution. Most of our legal cases, right up to my time in the Court of Appeal, the final Court of Appeal really was the Privy Council. And that's why I had on my walls all the English law books. That was just how I was taught law. But that changed in the course of my life, and therefore it became necessary for people to try and work out what is the foundation now of the Constitution. If it isn't the imperial power in Westminster, if that is so conflicting with the political realities of the world we live in, what is it? And in the case of Leith in the Commonwealth, the High Court, before my appointment to the Court of Appeal and before my appointment to the High Court, had said, in the words of Justice Dean, that the real foundation is the acceptance of the Constitution in the referendums that were held in the late 19th century, and so a historical explanation was given as to why it was the wishes of the people. Now, there were certain problems with that from a historical point of view, because the numbers of people who voted in those referendums didn't include women in most of the colonies, and therefore it wasn't an entirely comfortable theory, but it was the theory that we began in Australia to adopt, and it was one which was more respectful of our independence, our legal independence, and so I went along with that, and I still believe that that is the foundation of our Constitution. That's why I balk at the suggestion that opportunities are missed because of the people. Sometimes the people have shown great wisdom in rejecting constitutional amendments. One of the instances was the Communist Party Dissolution Act in 1950 and the referendum in 1951 that rejected. When that referendum was mooted after the High Court by 5-1 rejected the constitutional validity of the Act, when the referendum was proposed, the votes in the opinion polls showed that 80% of Australians favoured a ban on the Communist Party, because we had soldiers fighting in Korea at the time. So it wasn't, it was actually what Chief Justice Latham, the sole dissenter, said: being comes before well-being. That was something that Oliver Cromwell had written. Being, in other words, your existence and your continued existence in a peaceful society comes before well-being, your happiness, pleasure, and so on. But the majority of the judges, in a wonderful decision, one of the greatest decisions of the High Court, said that we can deal with communists for what they do, but for not for what they believe. And you can't ban them from having a political party and for seeking to get the concurrence of the citizens with them. They never did. They never got a majority. They never even won a single seat. But a single seat in the federal parliament. They won a seat in Queensland. But they were protected by the Constitution. And my grandfather, or my step-grandfather, had been a communist. And he never thought the High Court of Australia, the running lapdogs of the capitalist class, would ever protect his rights. But the High Court in the Communist Party case did. And that left a very indelible impression in my mind, because a kinder and better man you could not have met. He was the treasurer of the Communist Party, but he'd fought in Gallipoli. He was a New Zealander originally, and he became a communist, and it was sort of like a religion. And therefore, at the time, there would have been a few people, including Mr. R.G. Menzies, the Prime Minister, who thought that the people had made a terrible mistake. So he went to a referendum, and the referendum was fought, and it was won by the opposition. And that teaches that sometimes what appears to be wrong at the time can become accepted as wise in retrospect.
Yeah, I think that's I suppose that's a reality for some people personally that might struggle with, but I think your mentions also previously in engaging with civil society and engaging with other people. I mean, we are social beings, and I think that's something that's really important, and I thank you for your comments on that.
Yes, as well, it certainly is important, and it's very important for Australians to engage with the First Nations people. And if I look back on my life, when I was the president of the Union of the University of Sydney, I never asked a question about the First Nations people. I never asked a lecturer, why do we have the White Australia policy? I never asked anybody about the disadvantage that women suffered in the law, or people with disabilities, or gays. I never asked any questions about. I just accepted that's the law, and my job is to give it application.
Fair enough. I think it's quite interesting, the idea of what the people accept, and oftentimes not only is it necessary just on a social perspective to mix with other people, but I feel as though that gives you a bit more of a perspective on what the people truly want. Sometimes you can get your hopes up a lot for a particular constitutional change, and you realise the people you've been talking to about it are not necessarily representative of the white population.
It may be that the Voice referendum was defeated because it didn't really fulfil the wishes of the First Nations people, or that those wishes may be more radical. They may be for some form of treaty, because treaties were not unusual in British dominions. They existed in the United States, in the American colonies, in Canada, and certainly in New Zealand, where they had the Treaty of Waitangi. So it's more complicated than just foolish people not willing to accept this proposal for the dignity of the First Nations people. I voted for the referendum, but I can understand the point of view that there were reasons why, including some First Nations people themselves, were not convinced that this was the way ahead. And it wasn't really very well argued before the people, and you've got to prepare people for constitutional change. And if you live in Australia, where it's a pretty well-governed sort of society, when the law is generally obeyed, and the corruption is not very, very obvious, it's reasonable to be rather hesitant about changing things.
I think for a lot of current law students, that is their first referendum, their first Australian referendum. And I think coming from a sort of speaking personally, it was definitely something that you put a lot of keen interest into, especially looking at the legislative side. I mean, you yourself have lived through a couple of referendums, including the referendum on Australia to become a republic. Perhaps looking at that, was that something as well? You see that, I suppose, the political element of it is that referendums usually don't pass unless there's, both parties are supporting it, and at times as well, even when both parties do support it, the Australian people still vote no. So is it something that relates to perhaps informing people more, or what do you think?
Well, informing people more rather implies that the people have been foolish, whereas sometimes, as in the Communist Party case, the people proved themselves to be more prescient about our liberties than did the Parliament. So far as the Republic is concerned, I wasn't convinced that that was a step that was timely, certainly at that time, certainly in the reign of Queen Elizabeth, because a person of my age had grown up, the whole life had been with the Queen, whose importance was not for what she did, but what she kept other people out of doing. That is the system of constitutional monarchy. If you look at the countries where you could actually live, and which are peaceful, stable and democratic, the best of them seem to be constitutional monarchies. That may just be an accident, but it's a peculiar thing that you have a symbol, but they have no power, and they keep other people out of the job of the president.
Yes.
Just look at the situation in the United States at the moment, and whatever happens there, it's a sort of semi-chaotic system, and it depends on having an awful lot of money in order to be able to be the final candidate for one side of politics.
And sort of looking at from if you are, whilst being an active judicial officer in that process, is this something that what's the sort of things that you look at, I suppose, when these sorts of things are being passed? Are you you mentioned previously you weren't watching TV, but are you keeping up with the news? Are you following those sorts of things?
Well, I keep up with the news at the moment because it's so fantastical, the situation in the United States of America. The parliamentary system, which we have, would never have allowed a person like Mr. Trump to become the leader of government. It just wouldn't happen. And the Americans, poor things, inherited, as a result of their revolution, the constitutional arrangements of King George III, and therefore they have a king with overmighty power, and he's the head of state, the head of government, the head of the executive, the head of the armed services. It's too much power concentrated in one person, whereas the British constitutionalism continued to evolve into the 19th century, and there's a statue in this street, in Macquarie Street, Sydney, at the end. You've probably never even looked at it. It's the statue of Prince Albert, the partner of Queen Victoria, and it was he who taught Victoria, you reign, you do not rule, and therefore the system of constitutional monarchy evolved, and it's a mystery, but the question is, why are the countries like Spain, the Netherlands, and so on, generally peaceful and keep politicians in their place? I think that's a very important feature. And before you change it, you've got to be sure you're not mucking things up.
I suppose one of the things that law students learn first is the separation of powers. And I think as a concept, it's pretty amazing that humans thought of that these sort of ruling bodies and people ruling tend towards things like absolute sometimes corruption, sometimes abuse of those powers, and sort of strong use. And so for humanity to then set up barriers in order to, or sort of...
For the greater good.
Good, yes. I know, it's quite an amazing thought, especially, and sort of not making that power concentrated into, one person or several people. And so, it is an amazing thing. And I mean, I think...
It's interesting as well, though, because obviously in the United States, their separation of powers is quite strict, probably a lot stricter than in Australia. The legislative and executive sit in different houses, and yet
not only do they sit, but they must. They can only be out of Parliament for, I think it's 3 months, and they've got to find a seat, or they're out of the ministerial position. And the good thing about our parliamentary system, for all of its weaknesses and faults, is that they've got to sit on that front bench and answer questions. At the end of the day, or at the beginning of the parliamentary day, they will have to answer the questions of the opposition, and that is making accountability is really very important for a politically benign society that doesn't let people get too big for their boots. Now, I have a sort of home a constitutional monarchy, and my partner makes sure with me I never get too big for my boots. And I think that on a micro level is good for a human being, but on a macro level it's good for a society. You've got to control great power, because there are people who want to use it for crazy ideas, and that's why we've got to put checks on it.
Yeah, but it's still amazing, I suppose, to me that the people
You're
who are in that
easily
position,
amazed,
yes.
Oliver.
Yeah, well, no, but it's amazing that the people,
Curious mind.
the people that established that were people that had that power to begin with, and so it's almost as if you're limiting yourself from, or limiting futures people in that position as well, but limiting yourself in your own power. So yeah, it is interesting.
Well, let me just for a minute give you a little legal history. Albert came from Germany, and he married Victoria, but he had a teacher, and his teacher was Baron Stockmar, and Baron Stockmar taught him in Saxe-Coburg and Gotha in Germany that if this system is going to last, it'll only last if you accept limitations on your power. And that's what he taught Victoria. She wasn't a very good student of it, but Albert was, and Albert taught his children, and that really made a big difference in British constitutional history. And that's why, you know, when most of the other empires, the German, the French and others have collapsed, and the British Empire in the Commonwealth of Nations continues, and people want to continue to have connection with them. And I'll be going to Samoa in October for the latest CHOGM meeting, and it's still a viable institution, and people share their experiences, and that's a good thing for humanity.
That's great. We're approaching towards the end of the podcast. I'd just like to ask you now some standardised questions that we ask all of our guests. They're a little bit more personal and give a bit more insight into you. So starting off with the first one, what was your favourite subject in law school, and why?
It was legal history plus constitutional law plus international law. Don't forget, in my day everything was compulsory. You had virtually no choices. You had to do not the priestly 11 but the 1959 40 subjects. And that had its weaknesses, but it meant everybody got a fairly good grounding, and I loved the theoretical issues. And when I go to legal functions and they say, oh, we've got to make lawyers more practical and they've got to be practical, I say, yes, but they've got to get the theory. They've got to understand the sorts of things that we've been talking. It didn't take us long to get round to the rule of law and to the separation of powers and to the division and why we have that. And as you say, it's amazing that we have accepted it, but we have that. So there was a wonderful professor at the University of Sydney. He later became a professor at the University of New South Wales, so he's shared by both the law schools of that time in Sydney, Professor Julius Stone. And he was a great theoretician of the law, and he was a world-famous teacher, and he taught jurisprudence, and he took a shine to me. And I think that was partly because I was big time in the SRC, and he thought, well, this man's going somewhere. But he kept notes on outstanding students, and apparently I was in those notes, and so I loved and admired him, and he gave me opportunities. He got me writing a chapter in his second edition of a book he'd written on jurisprudence. So all of that made me very interested in legal theory, and you've got to be interested in legal theory if you're going to be a successful and useful member of a Court of Appeal or the High Court of Australia, because you're dealing not just with the little case, you're dealing with what happens if you decide that in a particular way, and the facts are a little bit different. You've got to see down the years. You've got to be able to see into the future.
I have a suspicion there might be a common denominator amongst members of the court and other judges. I spoke to Chief Justice Andrew Bell, and one of his favourite subject was Roman law. So again, a very similar historical element in relation to the law. So moving on to the second question, do you have a book that's significant to you and one you'd recommend to students?
Well, you could do worse than to pick up Julia Stone's book, Province and Function of Law, which was the book on jurisprudence that from which we were taught in New South Wales the subject of legal theory. But there are other books on international law and on legal history. It's a shocking thing that legal history is not compulsory, in my humble view, because how can you be a lawyer in a system of like a common law system where it's all written in the cases going back to 1100 and 1066? How can you be a lawyer if you don't know at least generally how it emerged and why it emerged? To answer your question, it's amazing that these things happen, but it's all bits and pieces of a long drama which begins in England for our system and which was a history of struggle of people for their dignity and rights, which was ultimately declared in the Universal Declaration of Human Rights. So these are the books, but nowadays I don't read only legal books. I read the London Review of Books. The London Review of Books has all these books I will never have time to read, but then you get a potted version of it, and at the moment I'm actually reading a very interesting book called France on Trial, and it's about the Vichy France during the German occupation, and Pétain, who'd been a great general in the First World War and became effectively the dictator of German sympathetic France during the Second World War. And it's a very interesting story about the struggle of the remnants of law to try to control the Vichy regime and what happened after the war. And there's history generally is very good. I came top of the state of New South Wales in history. If I had my time over again, I would probably become a professor of history. But I just had to settle for the law, which is all history.
Were you more inclined to modern or ancient history?
Oh, modern, yes. Ancient, the ancients are very important, but where do you start? And why do you exclude China's ancient history, which is even longer than that of Mesopotamia and the Western European tradition?
I think I agree. I did modern and ancient in Year 12. I was definitely more inclined towards modern history. We actually studied Chinese history as a part of that as well, which I think was really interesting. And as you say, a lot of the time you don't get as much exposure to different perspectives, but that was something that I really liked studying as well.
And we've got to study the history of our relationships with the First Nations people, because nobody asks the questions well, certainly in my time, nobody asked the question, well, what right did we have to barge into this huge country and just take it over and deny the indigenous original inhabitants any respect for their dignity and their culture and tradition? But I think we've got that message. But there are plenty of other things we need to study and to improve our minds and improve our practice. And I never put my hand up at law school and asked about the denial of the dignity of the indigenous people. Never. And you young lawyers have got to ask yourself, what are the subjects now that in my old age I'm going to be looking back and saying, I never asked anything about that. and I'm ashamed of the fact that I never asked anything about it, because those subjects will exist. They will include the way we treat refugees, the way we treat migrant, immigrant people, the way we treat people who have drug addiction and dependence, and people who are disabled in some way. Our Parliament only last week enacted a provision in a statute to deny the provision of sexual therapy to people with disabilities who cannot have a sexual life without assistance and therapy. You know, if anybody stops and thinks about their own life and their own sexual life, that is a very wrong thing for our Parliament to have done. And I hope that the federal court or a court in Australia can find a way to correct that.
I suppose now moving on to our next question. You mentioned it a bit previously, but did you always envision yourself practicing as a judge? And if not, what did you think you would do?
I don't regard being a judge as practicing. You practice as an advocate, you practice as a solicitor, you practice as a barrister, but you sit as a judge, and you are removed to some extent from the hurly-burly of the battle. But did I ever envisage doing anything else? Well, I've told you at the North Strathfield Public School at the age of 8, I already wanted to be a judge. Now, why was that? Because I'd seen a film called The Paradigm Case. I don't think it was before I was at the North Strathfield Public School, and I think it was probably when I was at Fort Street High School, and it was a case about a murder and a judge, and there was a great actor in it called Charles Lawton, who was the judge, and I thought, he's a bit pompous, but he's so in command, he's so in control, and I thought that doesn't look like a bad job, and so it was a job that I aspired to, and I've never regretted it, and I recommended it. But it's a job for total concentration, long hours of study and long hours of reading the briefs and the papers, listening attentively to the arguments, changing your mind, and keeping in the back of your mind the theory of the Constitution and the theory of our form of democracy, and trying to ensure that in the little tasks we all contribute to the big task of keeping a peaceful, sane, democratic and balanced society.
At what point in your life did your aspiration to become a bishop fall away?
Well, I wasn't holy enough to be a bishop, and my later experience and encounters with the church made me very, very disinclined to that line. But I went the other night to the 200th anniversary of the first meeting of the Parliament of New South Wales, and it was a magnificent service. If you've been brought up in a religious tradition and your parents have introduced you to that, it becomes and is lifelong and a very important peace-producing feeling within you. And so, though I am not a regular attender at Anglican services, I still love the canticles, and I love the liturgy, and I really appreciated the wonderful service that was held at St James Church the other day on the 200th anniversary. It's a pretty good thing, a peaceful country with 200 years of a form of parliamentary democracy. It's amazing. Not many countries in the world can boast of 200 years, and it's our duty as lawyers to preserve that and to strengthen it and to defend it.
We're now at the end of the podcast, and I just have one final question for you. Is there a final piece of advice that you've received that stands out from the rest, and one that you'd like to share to law students?
Well, the advice I've given and said and referred to in this discussion is the advice to work hard at university to try to get good grades, because that marks you in a way for the rest of your life and your aspirations, to focus, to go to student activities, to chair lots of meetings, but not necessarily as obsessively as I did, and to be proud of your profession, to be sympathetic to and respectful of your clients, to remember that it's not a fun day for them. It's a day of great stress, even greater than you're feeling. And so if you do all these things and keep all this advice, it's a wonderful profession, because it's a profession that is involved in the solving of puzzles. Every day is a puzzle, and especially if you have the good fortune to serve on an appellate court, but also in a trial court, or as a barrister or a solicitor. Solving puzzles is a wonderful way to remind yourself that you have sentience, you have rationality, and that is the precious gift of life. And it doesn't last forever, and you've got to make the most of it. And law is a way to have a useful life that serves society, and also you make a bit of money on the way.
Thank you so much for joining with me today, and I wish you all the best for the rest of the year.